What happens when probate turns into litigation? Well, that's called an adversary proceeding. In the vast majority of estate cases in the state of Florida, the will is filed, trust is filed sometimes, but the assets of the deceased pass to whoever the decedent says they should have passed to without much fighting, without much litigation. But in a small percentage of cases, but that percentage is growing rapidly, there is litigation involved in estates, and that litigation is in a couple of small categories. There are challenges to the wills, to the trust, to those documents, undue influence capacity, that line of cases. There are creditor claims in cases, and that is where dead guy's dead, but he owes his business partner money. Dead guy's dead, kids owed money, something like that. That would be a creditor claims in litigation. The interesting thing about this, the story that nobody will tell you, is that the number of actual probate litigators in the state of Florida is tiny. It's minuscule. That's because historically there hadn't been much fighting in probate. So you got these really well-known firms all across the state, and in every single town, there's one guy that did all the probate in town. And he just didn't want to be litigating probate cases. He didn't want to be fighting. And sometimes there's conflict of interest in there, so he can't litigate that case. So he would refer that out to the firm in town that did personal injury litigation or family law litigation or something like that. And that case would be litigated. But again, super tiny percentage of cases in which this exists, but that is exploding rapidly. We're going to see lots and lots about that. The other inside hack or story about this is the rules that govern this are very, very interesting. Interesting in the sense that there's not a whole lot of detail in them. Like the rest of the Florida rules on probate, I don't want to say they're made up as they go along, but I will say that the rules that exist don't cover nearly enough of the circumstances, so that leaves wide discretion in the part of the judge on how that case is going to be treated. Now, other interesting inside fact about this. So, unlike criminal law or family law or insurance law, where the rules and responsibilities about how the plaintiff lawyer, how the defense lawyer interacts are very well developed, down to granular detail about what information is provided to the defense in a prosecution case or in a family law case, all these financial disclosures and things like this. All this stuff developed over decades, and so the rules about how that operate are very precise, very, very specific. Exactly the opposite exists in probate. And in probate, there's almost no rules that really deal with those granular details that exist in all these other areas of law. What's going to be happening over the next couple of years is those details about how that is to be developed and how these cases are going to be litigated is absolutely going to be made clear and specific. But before that happens, you're left with experienced litigators doing their job to try and advocate best for their clients. And if you think you're heading into that territory of litigation, like and subscribe to this. We'll give you the booklet and the information that provides a whole lot of information on this very interesting and emerging topic.